Hi, everybody. Thanks for joining us today to talk about an area that is really quickly developing, and there's so much fascinating stuff going on in antitrust law as it applies to technology companies, both private litigation, government enforcement, proposed legislation, attention by the White House. There's just a lot to talk about when it comes to large technology companies and technology platforms in particular, and changing antitrust law. So I'm excited to get into it with you. By a quick way of introduction, my name is Alex Reese. I'm a partner in Firella's General Complex Litigation and our IP litigation groups. And for the last 10 years or so, there's been an aspect of my practice that has focused on sort of the overlap of technology disputes and unfair competition law. And I'll talk about a few of our engagements in that arena, but they range from sort of disputes that are more technology oriented that have some aspect of unfair competition, all the way to just antitrust counseling and antitrust litigation that I've been involved in and that our firm has handled. And so I'm very excited about this topic. I think it's really fascinating, and thanks for joining us. So here is sort of the agenda for today. Just really quickly, I'll give an overview of what do I mean by a technology platform. When I talk about it today, there are lots of possible definitions, but for purposes of our discussion today, what are we talking about here? I'll go over some examples of private antitrust lawsuits that have been in the news and talk a little bit about the kinds of theories and the ways these private cases tend to arise. Then I'll talk about some high-profile government enforcement action and the new movement among government enforcers called the Neo-Brandeisian or New Brandeis movement, which sort of seeks to cast a new lens on antitrust laws and what they mean and what our antitrust laws are meant to protect. I'll talk a little bit about legislation and White House attention, and then hopefully have some time for questions. There is a lot here, so I may do some stuff at a very surface level. Any one of these cases or theories you could talk about by itself for a full hour, but this presentation is meant more to be kind of an overview or an update on what's going on out there. So forgive me if I touch on some of the stuff that you're really interested in at just a super quick level, and I'm happy to dive into it further during the Q&A or just throw in questions through the chat function as we go. Okay, so what are we talking about when we're talking about a technology platform? Well, there are lots of possible definitions, but for our discussion today, what I really mean is it's software, it's technology that allows multiple parties to interact with each other, to transact business, and to store and manipulate or analyze data. That's what I'm talking about as a platform. It doesn't have to do all those things, but they usually do one or two, sometimes all three of those things. And this is a definition that's very similar to the one that you see in some legislation that's been proposed to regulate platforms. Some other things that technology platforms today often have that aren't sort of a core requirement, but often contributions by third parties will enhance the value of the platform. So third parties can contribute applications that sit on top of the platform and make it more bespoke for a certain line of business, or make it more user-friendly if it's a consumer-oriented platform. Another common aspect of platforms is there are strong network effects, which has implications for antitrust law. In other words, the more consumers, the more businesses are on this platform, the more powerful it gets. If Facebook were small, it would be less powerful than it is. Part of the draw is that all the people you know are on it, or maybe used to be on it, I guess I should say. And then another common aspect of technology platforms is that very frequently the platform owner can set and sometimes unilaterally change the rules of accessing the platform. So whether that's a terms of service agreement for a more consumer-oriented platform like Facebook or Instagram, or whether it's more like a business-to-business platform like Salesforce or Zendesk or something like that. Oftentimes there are relationships where the platform owner can set the rules and change them with notice to the users. That's not always the case, but it is a common aspect of these platforms that leads to some antitrust problems that we'll talk about later today. Some issues to think about as we're going through this presentation: is the platform primarily a social one or a business-to-business one? The antitrust implications are different. The privacy implications are different. the ability to unilaterally change the contract is usually different depending on whether it's a free service that's offered to consumers or whether it's a paid service that's offered primarily to businesses. So that's just something to kind of keep in the back of our minds. Another issue to consider in thinking about technology platforms is it acting primarily as a store, like an app store or Amazon or eBay, or is it acting primarily as a sort of business-to-business service, or primarily as a social engagement tool, a social platform? The kinds of service that the platform offers can lead to different kinds of antitrust issues. So why are technology platforms sort of a target-rich environment for antitrust issues? Well, there are a lot of reasons, but the ones that immediately come to mind for me are, as I mentioned, sometimes they have the power to unilaterally change access rules. That could be changing the terms of service if it's a consumer-oriented platform, but also many of these platforms, even business-to-business platforms, have API developer agreements where a third-party software developer can create applications that interact with the base platform. And even if the platform's contracts with their customers require mutual negotiation that can't be changed unilaterally, sometimes those API developer agreements still can be changed unilaterally by the platform. And so they have a bit of both. Another reason that antitrust issues tend to crop up for these platforms is that there is frequently a tension between the platform benefiting from developers being on the platform and also competing with them. And so we'll see this in one of the cases I'll talk about later, an Amazon case. Amazon acts both as a seller on its platform. You can buy Amazon branded products that it is in charge of the manufacturing stream and offers the product for sale. And then there's also Amazon Marketplace, where third parties come on and sell things that they have made or they own. And so the dual nature of the platform can cause some friction. You see this also in Salesforce is another example where oftentimes they will acquire successful app developers, and then all of a sudden Salesforce is competing with the other app developers that had been competing with the one that they just acquired. And you see it on other platforms as well. Those are just examples. And then the last factor, which we'll talk a little bit about when we get to the new Brandeis movement, is bigness. A lot of these tech platforms are just big, and that tends to draw attention from government enforcers and from the plaintiffs bar as well, because if it's a big company, that means deep pockets. So I wanted to spend a few minutes talking about some of the high-profile examples of private antitrust lawsuits against technology platforms. And to talk about them, they come in many different flavors. There are a lot of them out there, and so I'm sure that I will miss some. But here are the ones that I sort of thought made sense to group so that we could talk about the different kinds of private antitrust lawsuits we're seeing and paying attention to here at Varela. So the first category is sort of what you might call a walled garden claim. And you see these, there are many of them currently ongoing against both Apple's App Store and also Google Play, the Android store. And the idea here is that the technology platform has created an environment and you can be either in or out, but you can't, once you're in, you can't also collaborate with third parties that are outside the walled garden. And so we see that, one recent example was Cameron versus Apple. It's one of a series of claims by both app developers and users. And the essential claim there is the App Store prevents developers from selling their apps anywhere else. If you want to create an iOS app that's going to work on an iPhone, you can offer it for sale only through the App Store, and Apple takes a cut of any sale. And so the claim here is that's unfair competition, that violates the antitrust laws. We should be able to develop an app that works on an Apple iPhone or an iPad or whatever and sell it wherever we want. And maybe there will be other stores that will offer our app and take less of a cut, and that will create competition for Apple. Apple is insulating its App Store from competition by refusing to allow us to sell our apps anywhere else. And it's the same claim against the Android store. And so you can see this claim sort of directly from the developers, and Cameron versus Apple was one of those. There are similar claims going on in Europe. Well, the French one is actually here in the United States, but the Dutch one is in Europe on behalf of both consumers and developers. And the consumer theory is sort of like it's like a pass-through theory that because the App Store is more expensive, consumers suffer the downstream consequences of that. For the developers, it's more of a direct claim. You're taking more money away from each sale of my app than you would be able to if you allowed competition. And the Cameron versus Apple one was ongoing for quite some time and recently settled, I think just a few months ago for $100 million. So, in the scope of antitrust lawsuits, it's not enormous, but significant liability here, obviously. Another interesting one in this vein is the Cydia versus Apple. It's currently on appeal to the Ninth Circuit, but that was a direct competitor lawsuit. Cydia claimed to be a competing online store that would host apps and wanted to sell apps, and also that they allowed a technology to jailbreak phones so that you could purchase apps from them as opposed to through the App Store. And they claimed similar theory that Apple's policies prevented this kind of competition and that they were harmed by it. And as I mentioned, there are similar lawsuits going on against Google as well. There was a recent $90 million settlement with so-called small, it was a class of small application developers. And then there's an ongoing MDL as well, which I think involves both consumer and developer claims, but I'm not certain about that. So there's a lot of activity here. There's a lot of claims that these platforms are unfairly restricting the people who are on the platform from doing their business elsewhere. And this isn't in the slide, but the most recent one to really get a ruling on the merits was the Apple versus Epic Games, which didn't directly challenge the App Store, the alleged App Store monopoly. Instead, it said that in-app purchases, Apple was taking too much of a cut of in-app purchases. And there was kind of a mixed outcome there, but Judge Gonzalez-Rogers here in Oakland ruled that it did violate the unfair competition law, rejected some of the antitrust claims, but did find some liability. So then what are some other theories that we see out there aside from these sort of walled garden theories? Well, there are a couple that we've seen recently that I can only classify as sort of creative theories. If they move forward, I think they would make some law. They're very interesting, and so they're good ones to watch to see whether private plaintiffs are going to have success in sort of expanding the scope of antitrust liability for these platforms. So the first one is one that was filed very recently in San Francisco Superior Court. It's a proposed class action of drivers that sued Uber and Lyft, alleging an antitrust theory. And the theory there, I classify as a creative one because it has a real tie-in with the ongoing fight between drivers and these ride-sharing companies on whether they are properly classified as employees or independent contractors. And I think probably all of us on the Zoom here are in California, and so probably have some familiarity that there's been state legislation proposed on how these drivers should be classified. There was a ballot initiative to fight that. It's been a long-going fight, and this seems to be the next step where the drivers are alleging that because they are classified as independent contractors and not as employees, then the ride-sharing companies should not be allowed to set ride prices, that's a form of vertical price fixing. And they have some other claims as well that aren't really like a price fixing theory, but more just sort of a restraint of competition theory that talk about how the ride-sharing companies dictate which rides must be accepted. And they don't, as far as I understand, they don't actually dictate it, but if the driver refuses a ride, there can be penalties for that. And so they're trying to marry together this concept that, well, you say we're independent contractors, but here you're dictating all the economic terms of how we perform our duties. And so that violates antitrust laws. It's an interesting theory. I'm not aware of a case that sort of ties in labor law and antitrust theory in this unique way. So it'll be a fun one to watch. Then another one that I classify in sort of creative theory against tech platforms is one that was filed in Northern District of California earlier this year called Crowder versus LinkedIn. It's quite a long complaint, I think over 100 pages long, and it has some really interesting allegations in there. First, they allege quite plainly that Facebook and LinkedIn, well, I guess now Meta and LinkedIn, entered an agreement to divide up the social networking space, that Facebook would have personal social networking and LinkedIn would have professional social networking, and they agreed not to compete with each other and to just sort of divide up the social networking territory, which, if true, would be sort of a classic antitrust violation. You can't agree with a competitor to divide up territory and to refrain from competing with each other. And then they also have sort of a separate theory that talks about once LinkedIn secured this monopoly through the agreement with Facebook, they amassed an enormous amount of professional social media data. So data used by professionals in their career, right? Like, where did you work? Where did you go to school? How long did you work there? What positions did you have? Other, professional certifications. They have an enormous universe of data on this subject. And then they also have allegations, it's a really wide-ranging complaint, that after the Microsoft acquisition of LinkedIn boosted all of its AI and machine learning capabilities to analyze that data. And so now it has something of a monopoly for the analysis on professional social networking data. That's kind of the theory, the core theory. And that LinkedIn protects that monopoly by refusing to allow third parties to analyze the data. And they have terms in their terms of use that really restrict how you can use the platform data. Not only can third parties not come in and analyze it, you as the user can't even automatically collect it. So if you wanted to just automatically download all of your LinkedIn data, there's a provision in the terms of service that says you can't do that, even though you own it. So it's an interesting theory. I classify it in the creative group mostly because of these sort of interlocking allegations of the agreement with Facebook and then the acquisition by Microsoft. It's just a really complex web of how they get to their, what I think is their core allegation, which is they have precluded third parties from engaging in the data analytics industry in a meaningful way. And they've done that, according to the complaint, through this agreement with Facebook, the acquisition by Microsoft, and the terms of service. Then another common way that private antitrust lawsuits arise, and after we talk about this, I'll move on to some public enforcement that's very much in the news. A really common way that antitrust or unfair competition claims arise for tech platforms is when there's a termination event. And a termination event can come up in a number of ways. But one that was very notorious in the Bay Area from probably 10 years ago at this point was a decision by Twitter back then to deprecate its API, to change the terms on which developers could access the platform through the API feed. And what preceded that change was there was open and free access to the Twitter API, where third-party developers could build an app to access Twitter data and analyze it and sell analytics services, or maybe even build an application that would sit on top of the Twitter platform and provide modifications or customizations, things like that. And so there was this really big universe of companies that had formed all on the premise that they could continue accessing the Twitter API. and they sort of based their businesses on that assumption. And then Twitter basically shut it off and kind of shut down access for many, many, many of these companies, which the agreement allowed them to do. As I mentioned before, a lot of API agreements say, look, we're giving you this API access for free, and so we can just turn it off whenever we want. And so that's what Twitter did for many of these companies. But People Browser was a data analytics company that sued them. This case didn't get very far before settling, but the allegations in it were really interesting. It was in San Francisco Superior Court, if memory serves. And the allegation was basically, there was sort of a combination of promissory estoppel and antitrust claims. The promissory estoppel theory was, you told us, Twitter, through public statements and through direct interactions with us, that as long as we follow the rules, we would continue to have access to the API. And then we built a whole business around that promise, and then you shut off the lights. And then the antitrust angle was, there was an allegation that Twitter was simultaneously launching a competing product, that they wanted to do the same sort of analytics that People Browser was offering, and that's what drove the decision to change the API access agreement. There are also there are also similar theories with respect to independent software vendors, or ISVs. So I didn't talk about this earlier, but a lot of these platforms, they have a web of connections. They have users that come on and use the service, whether that's a business or an individual. They have agreements with developers through their API feed. Many of them also have third-party independent software vendors that will create modifications to the platform or integrations so that the platform can work with other technology systems. And so they have contracts where these third-party software developers can build software that sits on top of the base platform. And so the most well-known example of this, and probably most successful, is Salesforce. So Salesforce has this base CRM platform that is very widely used, obviously. And then they have thousands of third-party developers that create integrations or customizations or make the platform work better for your trucking company or your restaurant or your, whatever business you might be in. There are software developers out there that make it work better for you, or they make it integrate with other software systems that you might have. So you want to use your customer relationships management software from Salesforce, but you want it to integrate with your marketing software, or you want it to integrate with your sort of complaints and consumer grievance department. And so there are companies that build those integrations. All of those integrations and customizations make the base platform much more valuable. More users can come use it. It becomes more appealing. Engagement increases. The amount of time people use the software increases. And so it's very much in Salesforce's interest to have as many developers out there helping to build the platform and make it better as they possibly can. So how can antitrust issues arise here? Well, the most obvious example, and this was a private engagement that didn't turn into litigation, so I'll just talk about it anonymously. But it was a similar situation to what I've just described. And the base platform decided that they were going to acquire one of several application developers that were all competing with each other in the same space. So there were 3 or 4 companies that all offered the same kind of customization and integration on top of the base platform. And the base platform company said, we're going to buy one of you. And then after that acquisition, they immediately threatened to dramatically change the terms of the agreements with the other 3 that had not been acquired. The rationale for this is often in these ISV agreements, you see it in API access agreements too, by the way, but often those agreements prohibit the third parties from creating functionality that competes with the platform or that mimics a core function of the platform. So they want you to build modifications, they don't want you to replicate the platform. The problem is, if the base platform goes out and acquires one of 3 or 4 competitors, well, now those 3 or 4 app developers are all competing with an aspect of the platform. It's a new aspect, an aspect that was added by acquisition, but still the platform has an argument that all of these third-party software developers are competing now. And so they shut them down, or they change the terms, they make it more expensive. And so this was a case where it almost led to litigation. Fortunately, we were able to resolve it beforehand, but we were representing an independent software vendor trying to persuade the platform that they really couldn't change the terms of the agreement in a way that was deeply unfair to our client, and that would be anti-competitive. Another kind of termination event, and it's not exactly termination, it's more like exclusion, but a lot of these platforms, because they're so rich with data, they are the targets of third-party analytics companies that want to come and automatically collect or scrape their data. And so scrapers are out there trying to collect data from Instagram, Twitter, Facebook, all these platforms, LinkedIn. And for many years, the way that the platforms stopped this behavior was by sending cease and desist letters to the scrapers and saying, if you continue to scrape our website, you're going to be liable for violating an anti-hacking law called the Computer Fraud and Abuse Act. Our firm was engaged in a very widely publicized case that changed the law on the Computer Fraud and Abuse Act called HiQ Labs versus LinkedIn several years ago, and basically established that scraping companies have pretty much a complete right to collect publicly available data. That any data that's not behind, that was not behind LinkedIn's password wall was free to the public, and scrapers could go collect it. That was the Computer Fraud and Abuse Act angle of that case, and it really changed the law there. There was also an antitrust element to it, because that one of our allegations was that the reason LinkedIn sent our client a cease and desist letter threatening litigation and threatening to technologically prevent them from accessing the platform was because LinkedIn wanted to go into the same line of business. They were about to launch a competing analytics product, and so they wanted to clear the field of competitors. And both the district court and the Ninth Circuit Court on Appeal, neither of those courts reached the merits of that claim, but they both expressed real deep reservations that a company could wield the laws this way and exercise that kind of power over platform data to exclude competitors. The reason I wanted to mention this one is because this space is really heating up. For anybody who pays attention to Computer Fraud and Abuse Act stuff, there is just a lot of litigation going on by platforms, largely Meta, against software analytics companies. We're involved in a handful of those lawsuits, and our clients are getting sued basically because the platforms don't want them to continue collecting this data. They want to control the data. And so that comes back to the Crowder versus LinkedIn case that I mentioned that talked about controlling data. And you will see sort of this theme echoed later on when we talk about legislation as well. The power that these companies have by virtue of their massive data sets and the way that they control that data is increasingly becoming a topic of interest to the private antitrust bar. All right. So having talked about private lawsuits in the antitrust space against tech platforms, I thought I'd also touch a little bit on government enforcement. Once again, I'll just say there is a lot here. The FTC and the DOJ and the state attorneys general have been very active lately. There is renewed vigor to apply antitrust laws against large technology companies, including platform companies. And so there's really a lot to talk about here. I tried to pick just the two that I thought were sort of the highest profile or the most interesting. And so the first is obviously the FTC case that's ongoing against Meta. And the FTC was joined in that case by 46 different states. So what's the core allegation in this case? The core allegation is basically Facebook acquired a monopoly on social media, on a social media platform. And then instead of, the complaint says, instead of just being happy with that monopoly, they then took action to sort of consolidate and protect that monopoly through acts of unfair competition. And so how did they do that? Well, according to the complaint, the two main things that it did was to acquire competitors that were in adjacent spaces to the core Facebook platform, but that Facebook was worried might break into social media, and to prevent them from doing that, basically. And so Instagram was the first, WhatsApp was the second. And so there are internal Facebook emails and statements quoted in the complaint, which is quite detailed, where Mark Zuckerberg and other senior people in the company are talking about the competitive threats that Instagram or WhatsApp pose for the platform, and how the best way to address this threat is to just buy those companies and prevent them from turning into companies that will directly compete with Facebook. So there's a quote here, in the second bullet, which is sort of the core theory. Facebook has maintained its monopoly position by buying up companies that present competitive threats and imposing restrictive policies that unjustifiably hinder actual or potential rivals. Just for folks who think about antitrust stuff, when you're talking about technology platforms or large tech companies, one of the hard things is always to figure out what the market is. The market definition exercise is often very complicated. And even companies that seem like they have an enormous market share, like Google search, for example, if you just define it as online search, the rejoinder from these large companies is always, oh, but there are other competitors. There's Bing out there, or there's some others now that have cropped up that compete with us and prevent us from actually kind of hitting the monopoly threshold. And so Facebook historically always pointed to LinkedIn, and before it acquired it, Instagram and other companies, Twitter, as social networking companies that compete with it, that have a share of the market. And so the market here that the FTC defined was personal social networking. And you can see it hasn't been fully litigated yet, but you can see by them saying personal social networking, they're probably aiming at excluding LinkedIn from that definition as a competitor, which would then give Facebook or Meta a larger market share, obviously. Another interesting aspect of this complaint is the FTC's focus on network effects and barriers to entry. Really, those are kind of the same thing, but how the fact that a social network gets stronger the more people there are on it is a really powerful barrier for competitors. It is hard to compete against a social network that already has billions of users. Where do you start? What's your value proposition? How can you get people to switch over if there are only 5 other people on your platform? And so there's a thread in antitrust law that talks about network effects and how that can create an environment more ripe for antitrust violations. And so it seems that the FTC is going to be exploring that and trying to make ground on this particular type of business, that if you are in a line of business where there are really strong network effects, then that can induce stronger antitrust scrutiny because it's harder for competitors to break into your space. Possibly there's going to be an argument that the threshold for being a monopolist is lower if you're in a market like this. And then I did just want to touch on sort of the second aspect of their allegation here, the part that says that Meta unjustifiably hinders actual or potential rivals. So the first part of the allegation is really focused on previous acquisitions, Instagram and WhatsApp. Second part of that core allegation is talking about their API access agreements, which we've talked about before, obviously. So the API access agreement, at least as alleged in the FTC complaint, is typical. A lot of API access agreements are like this. They allow third parties to access the API feed, but only on the condition that they refrain from providing the same core functions that Facebook offers. So basically, the offer that the platform here, Meta, is making to third parties is, yeah, come use our API, analyze our data, create a data analytics company or an integration or an application that sits on the platform, whatever you want, as long as you don't replicate our core platform. We don't want you to be using our data to compete with us, which makes good business sense. Here, the allegation is that that unfairly restricts competition. And there may be an interplay between the strong network effects part of the complaint and the why this actually hinders competition to an extent that it violates antitrust laws. All right, so that's the FTC versus Meta case. The one other government action that I want to talk about, I'll just check my time here, is a one that was filed quite recently by the California Attorney General against Amazon. This is in state court, and as you may know, Amazon generally, at least alleged in this complaint, Amazon generally has a policy that third-party sellers cannot offer lower prices anywhere else. So if you want to come onto Amazon's platform and get access to the enormous number of consumers that are connected to that platform, you have to promise Amazon that you're going to offer your lowest price. You can't turn around and sell the same thing at Walmart or Target for a lower price. And so the allegation here in the complaint by the AG is that that's anti-competitive. And one of the reasons is that Amazon itself also sells products on its platforms. And so I talked about this way back at the beginning of the talk about how platforms often have this dual role, that they are a host for third parties, but then sometimes they also compete directly with those third parties. And we talked a little bit about it with the Salesforce example, where they acquire one of their app developers. And so here, it's not through acquisition, it's just sort of how the company came to be that, a long time ago, Amazon didn't have any Amazon branded products. It didn't sell any of its own stuff. Now it does. And so in some ways it is the store, but it's also in its own store, sitting side by side with third-party vendors that are trying to sell things at the same time. And so the complaint takes aim at that and says that because of this dual role that Amazon plays, the agreements requiring the lowest price are facially anti-competitive horizontal price restraints. That in effect, Amazon sets a policy in its role as platform that you have to offer your lowest price, but then that benefits it as competitor, as a party that competes with the sellers on its platform. And here again, because we talked about it with the Meta complaint, I wanted to talk about the market definition. So the market definition in this complaint it's here in the bottom bullet point: online retail sales of new products for custom delivery. Pretty interesting, quite specific, right? So what are they trying to do there? I mean, some guesswork here, but it's not too big a secret. So if the market were online sales, it would include Amazon, Etsy, eBay, Barnes and Noble, Target, Walmart. Like, everybody sells online, right? So it can't just be online sales. Okay, so they need to restrict it a little bit. Online retail sales of new products. All right, so that probably gets rid of eBay. I don't think that eBay offers any new products. I think it's all used stuff. I may be wrong. It's been a while since I've used that one, so I may be wrong. And then for custom delivery, that's also an interesting one. So the way they explain it in the complaint is custom delivery essentially means for delivery to your home. And so what they're trying to do there is exclude from the relevant market all of the stores, especially since COVID, where you can go and order something to be picked up at the store, which now is virtually every store of any significant size, right? You can go and pick things up. And so they're trying to keep those companies out of the market, which then will boost Amazon's market share and make it easier to prove that it is in fact a monopolist. So it's very interesting how the government has been defining the markets to sort of really focus in on, well, what makes this platform unique or different. And I think it's going to be a tough challenge for them, because the sort of traditional market definition exercise is for a court to look at near competitors and see, well, if a price change by this near competitor restrains Amazon from changing its prices, if their price change affects Amazon's prices, then it's a competitor. It should be in the market. There are nuances there, but that's kind of the basic analysis. And so I would guess that Amazon's attorneys are going to make an argument here that no, Amazon has to watch stores. They have to watch prices on eBay. They have to watch prices on Home Depot, even if Home Depot doesn't deliver to your home, and you have to pick it up in the store. They have to watch those prices, and so they should be included in the market. And you need to get rid of this market definition, change it, and make it broader. Okay, so in just a few minutes, I'll talk a little bit about sort of the government writ large, what's going on with our enforcers, not in specific actions, or not in specific lawsuits, but sort of what's the trend among the enforcers, and then also some legislation and some White House comments that are of interest. So one of the really fascinating things that's happening, not just in academic discourse, but it's having a real impact on policy, and you can see it in some of these claims that the FTC is bringing, is the new Brandeis movement. And so what is that? Well, just very quickly, for probably the last 45 years, maybe more, it has gotten progressively harder for antitrust plaintiffs to prove a claim. Year by year, the theories get narrower and narrower, the burden gets harder and harder, and you see it in a number of ways. The biggest change probably is in the 1970s, there was a long list of pricing decisions and other kind of competitive decisions that were per se unlawful. In other words, you didn't have to do any kind of cost-benefit analysis. If you could prove that somebody did it, it was a violation. Resale price maintenance is an example. If you were a manufacturer, you could not dictate to distributors what the resale price had to be. You couldn't set a floor for the price, and you couldn't set a ceiling for the price either. That used to be per se unlawful. Then over time, this sort of Chicago School of Economic Thought in law took over and analyzed each one of those per se things one by one. And a lot of them have fallen off the list, and they're no longer per se unlawful. Now they fall under what's called a rule of reason, sometimes quick look analysis, but the general category is rule of reason, where a court has to look at the sort of actual competitive effects of the activity. Are there pro-competitive reasons that you might set a price floor for your distributors? Are there anti-competitive consequences, and how do they balance out? And so just in terms of the cost, if you're looking at it from the plaintiff side, the cost of proving a case like that is astronomically higher than if you can say, no, this is a per se violation. You'd probably win a lot of those cases at the summary judgment stage. Now it's multiple experts on cost benefit, rule of reason, cost benefit analysis, consumer harm, all that kind of thing. Another area where it's gotten much harder is market definition, where it's used to allow very thin relevant market allegations to get past a motion to dismiss. Then Twombly changed that. Twombly was itself an antitrust case, and many courts have interpreted Twombly to have special application in antitrust cases. So you now have these complaints with 10 pages of market definition, and you have to hire an economist before you can even allege your claim. So that, for good or ill, that generally is what has happened in antitrust law for the past 45 years or so. It's gotten harder for plaintiffs. The new Brandeis movement is really pushing back on that. They're saying this Chicago school of thought is wrong, and the focus on consumer harm is wrong. And there are lots of things that we should take into account when we're thinking about how to apply the antitrust laws. So Lena Khan is, a very famous proponent of this. She's now head of the FTC. And this is from her sort of landmark paper that she wrote, I think, while she was still in law school. But the undue focus on consumer welfare is misguided. Consumer welfare is kind of a stand-in here for economic thinking of Chicago Economic School. Congress passed antitrust laws to promote a host of political economic ends, including our interests as workers, producers, entrepreneurs, and citizens. Antitrust law and competition policy should promote not welfare, but competitive markets. So what's she saying there? She's really saying you can't just focus on, does this pricing policy or does this acquisition harm consumers? Does it make it more expensive? You have to consider the entire structure of our economy. You have to consider other competitors. You have to consider workers, producers, entrepreneurs, all of those things in deciding whether something is anti-competitive. And so the focus is much broader on structural concerns, market conditions. Our goal in enforcing antitrust law, according to this new Brandeis movement, should be to create an environment that allows vigorous competition, not to look at each, one interaction at a time and decide, does this harm consumers? And then I just thought this was funny in getting ready for the presentation. I wanted to figure out better why, I knew that Brandeis was a big antitrust thinker, but why do they call him this quote? He called economic concentration the curse of bigness. And so it comes back to this comment from the top of the presentation where why are legislators and the White House and enforcers looking harder at tech platforms? Because they're big. And this is an aspect of some of the comments you see from these new Brandeis folks is a company that is that big, there's got to be some antitrust problem here. And we're going to take a harder look. Okay, so in just a few minutes, I wanted to touch on proposed legislation. There is a lot. And so I just wanted to talk to the one that, at least until a couple months ago, seemed to have the most legs. And that was Senator Amy Klobuchar's American Innovation and Choice Online Act. The reason I say that it seemed to have most legs is it had a pretty long list of bipartisan co-sponsors and made it through committee. And then I think what happened is it just kind of got stuck in the congressional quagmire this fall, and now it's just sitting on a shelf. So there's no current activity on it, but there also hasn't been, a down vote or any indication that Senator Klobuchar and her co-sponsors are not going to continue pursuing it. So what does this legislation do? A range of things, but it really is targeting platforms in particular, not just big tech. And it would prevent platforms, among other things, from giving favorable treatment to their own products. So there's been some concern that, for example, there are allegations against Google for doing this. If you search for a video in the Google search bar, you're much more likely to get a YouTube hit than a Vimeo hit or some other provider. So it would prevent that kind of favoring their own products. It also prevent discriminating in terms of service and restricting interoperability. And it really is aimed at bigness. It's another interesting thing. There's a threshold for size of company that the law would apply to, and the size is 550 billion. So it really is just targeting the largest platforms. Then there's also been, a lot of interest from the White House as well. The White House was supportive of Senator Klobuchar's legislation. And then just a couple months ago, the Biden administration released a statement with 6 areas of concern relating to big tech. including privacy, mental health, disinformation, other things. But competition was the first one listed. And this is the last quote from that statement, talking about a small number of dominant internet platforms use their power to exclude market entrants, et cetera, et cetera. So there really is quite a bit of interest across the political spectrum in Washington, D.C. on platforms and large tech companies in general. So that's all I've got for today. I know I felt like I was running at 1,000,000 miles an hour, so I'm sorry if we didn't dive deep enough into some of these topics, but I'm happy to answer any questions.